everyone, I'm going to give you all a minute to log in from the waiting room. And in the meantime, I will launch the closed captions. And when those are up and running, you'll see a little red live box at the top of your screen. You can click on that to access the closed captions. All right, you should be up and running. All right, well, welcome everyone. My name is Christy Baglow. I'm the Director of Statewide Training at Florida Legal Services. I'm delighted you have chosen to spend your Friday afternoon with us. Happy Friday, learning about foster care adoptions. And today we have with us Maria Bates, who is a volunteer advocate, does whatever Robin Rosenberg asks of her from Florida's Children First. So I really appreciate her putting together, she has put together just an amazing amount of materials to go with this webinar. So this is being recorded. I know you're going to want to go back and watch it and try to remember all the good stuff she's teaching you. And I'll also send out the shared materials tomorrow. So thank you to Florida's Children First for sharing this with our statewide audience. I really appreciate their willingness to share all this information with us. CLE has been approved and it will be announced at the end. So Maria Bates has her own nonprofit and law firm, and I'm going to let her go into more details about her exciting background. So welcome, Maria.
Hi, thank you, Christy. It is a pleasure to be here today, first of all, and I'm going to just chat a minute because I see that we still are adding a few participants before I dig into anything.
I'll launch the poll before I forget.
And Christy will launch the poll. I am used to training people in person, and so the webinar is always an exciting adventure because I can't see any of you. We will go through lots of slides and lots of documents so that you have the nuts and bolts of foster care adoption finalizations during this training, and then the documents will be provided to you after the training. And you may have some questions that, we will take pauses to answer between slides, and then we will try to save some time at the end for some questions and answers. But my email and my cell phone is also on the presentation, and you're welcome to reach out to me directly. And always, Florida's Children First is available. Robin Rosenberg is not with us today, but she is always a resource, and I count on her all the time. So I see some of the poll percentages are coming up. So let me introduce myself to those of you who do not know me. I am Maria Bates. I am an attorney. I went back to law school at 30, and so my first career was actually in counseling, and I worked in group homes with kids and some foster care work, some addictions work, mental health work, and then did some business consulting before I decided to go back to law school. I'm actually finishing my Master of Laws right now in business law at Florida State at the end of this month, so July is a busy month for me. I am an adoptive mom 4 times over, which means I've had 4 home studies written about me, and I have gone through at least 9 post-placement visits and seen guardian ad litems and had caseworkers and attorneys and all that kind of stuff. And you can see on the slide, you can see those are my 4 kids. And I, as a counselor, and I actually started a nonprofit adoption agency while I was in law school, and I ran that as executive director. My job was sometimes to write adoption home studies, and sometimes I supervised child studies, which we'll talk about a little bit later. And I also did counseling. We did private placements and we did foster care placements. We also had some contracts to do studies for our local agency. Pinellas County is my home agency, although I am joining you today from Manatee County, which is where I have a farm now. As many of you probably know, since you are I see at least 24% nonprofit legal aid attorneys out there. Working in the field of foster care and child welfare can run you into the ground pretty easily and quickly. And so having the farm for me was sort of one of my ways to escape. So this is my farm office, and you probably won't see any of the animals in the back because they're put in the back pasture right now, but it's always a fun time to be on the farm because we had a baby deer a few weeks ago, and we saw a cool stick bug the other day and all of that kind of stuff. So I think that's enough about me, unless I've forgotten something, Christy, you want to interject.
I don't think so. Wonderful background. I'm glad to hear you went back to law school late like I did.
Yes.
The way to make yourself feel really old.
Yeah, well, and I will add to that. So as a lawyer, I have handled, all different sides of that, and I have done several foster care adoption finalizations, so much so that it's sort of living and breathing. And as I was preparing this presentation, I was like, oh yeah, you know it because you do it for so long, but when you go back and connect the dots to the statutes again, you're always learning something, which thanks to a good colleague of mine, Susan Levine, who always reminds me that we are in the practice of law. And so it's an ever-growing awareness about new information, new laws. Robin Rosenberg just did a recent training on the legislative updates and such, so you're just constantly growing. So that's
We've got a good variety. Are you able to see the results on the screen? And a good variety of attendees.
So we have it looks like I have 25% nonprofit legal aid attorneys. Another 17% are foster parent or guardian ad litem volunteers, some pro bono attorneys, student, DCF attorney, caseworker, volunteers, and a few social workers. So for some of you, if you're not an attorney, you may get, gloss over some of the legal aspects of this. We are planning to prepare something maybe in the fall as a follow-up for families too on this. So if there's questions that you have that don't sort of fit into this presentation, you can always email me and we can put them in for the next presentation. Okay, so shall we jump in?
Go ahead. It looks like we have quite an even split on the experience level too. So.
Oh, I don't see that.
Oh yeah, it's you have to scroll down.
Oh, down. Okay. All right.
Everyone for doing the poll.
Yes, I love polls because usually in person I'm able to identify who's in the audience, so we can speak to your questions. Okay, so let's get started. And Christy, if you can advance to slide 3 about the adoption process. Just slow down. This was one of the most fun slides I put together because the reason why I volunteer to present on this topic is because I believe that there are a lot of attorneys out there doing what we're calling paper pushing, which is in essence getting a consent packet, filing a petition, finalizing the hearing, and then done. And sometimes they lose sight of, or maybe they're not even aware of, the really big picture of adoption. Adoption is not a one-time event. The legal part of adoption is a one-time event. Hold on, I'm seeing a thing, Christy. Since you showed the poll results, my screen is black. I don't know if everybody's screen is black. Can anyone see the? Can everyone see the presentation? Okay, they can see it. All right, so we'll go back to slide 3. So I created this diagram, and as you can see here, these are gears. When I think of child welfare, I think of it as a really big industrial complex. And there's all of these people who are participating inside and outside. And what I wanted to show you is that, one part turns the other part, turns the other part. And you could play with this diagram, which I did many times over to kind of try to give a sense of this adoption process. And what I wanted you to learn from this slide really is how can your work make the whole system better? And how can your work make a difference in this child's life and other children's lives? And I put some examples there from the bio-legal parents, family, questions they may have, feelings they may have from the child, the adoptive parents, the case managers, the guardians, and attorneys, and what are their roles in the different parts of the process. So, and some of this will differ based upon the child's experience. So we may have a child who is, born into the system in a home for 2 years, gets adopted and knows nothing else. And we may have a child who's been in the system who has been adopted, the adoption didn't work out, and we're back at a second adoption. They all have very different experiences, but our role in the adoption process and the finalization of the adoption process should take those feelings, thoughts, and experiences into consideration. So when we are moving through this entire presentation and we're thinking about how we're drafting language, how we're presenting the documents to our clients, how we're preparing our clients, how we're engaging our clients, and how we are setting up the final adoption hearing and beyond, these are some things to help you think through questions you might ask your clients, considerations you might have for how to improve the experience for everyone involved. And I've seen a lot of different experiences. I've had courtrooms full of 50, 100 people. I've had courtrooms full of 3 people, and everybody experiences it differently. So we'll move on to the next slide. So again, the concept in this training is really about moving on beyond pushing paper, right? And again, you could start from just the perspective of, I get a consent packet, I file the petition, I show up to the final hearing, and I send my client the birth certificate at the end. What I want you to do is to start from the perspective of you are their attorney. You're identifying yourself as the attorney for the prospective adoptive parent or parents. And you want to think about the rules, the professional conduct, and what your role is in that. So we are attorneys at law, we are counselors at law. So the more you know about it, the better you are in helping your client prepare for this. So some of the questions you want to start with in your own internal process is, why do I do this work? What do you think the real goals of adoption are? So some people think of it as forever families. Some people think of it as keeping children safe. Some people think about it as helping children be whole. If your concept and your goal is that we're building forever families and we're helping children be whole, you may think about the bigger picture of open adoption and how could you help your clients think through whether or not they want to have some level of contact with the child's siblings if they're separated and the child's biological family. In the bigger scheme of things, when we talk about keeping children whole in the adoption concept, it is a child knowing their history, understanding their history, and feeling they're empowered to make the decisions about who they want to be in touch with and not. If you think that is just about getting the client finalizing an adoption and doing your job in and out, then you're really just going to keep pushing paper. So I am guessing that those of you who are on the call today don't come from that perspective, but it is something I encourage everybody to think about. What are these bigger conversations you want to have in your head about it? Because it will guide how you have conversations with your clients. The next thing is to identify who is your client, right? Remember in this process that there are conflicts of interest. Many of us who do this also have relationships in the community. You have to think about where your referrals are coming from. You have to think about whether or not you played a role in some aspect of that adoption. I have heard from people who are regional counsel and also do adoption finalizations. So what you want to do is identify and be clear who your client is. That will also determine whether or not you have any conflict of interest. And if you have a conflict of interest, you need to look to the Florida Bar rules on that and identify if you need to get conflict waivers or if it's just something you cannot do and you need to refer it out to someone else. You know, people who are friends will come to you and say, I want you to do it. I only want you to do it. But you have to remember, at the end of the day, you are an attorney. You have these rules of professional conduct, and you have to make sure that you are able to provide the full level of service that is needed for your client. The next question is, what is the scope of representation? What are your duties and obligations? So one of the, moving from the paper pushing to the whole big picture of protecting your clients is you want to think about what are you actually offering to them? And if you are limiting your representation to certain things, you need to make that clear. You need to make it clear in your engagement letters and your first conversations and such. And one of the most important topics I think of is privacy and confidentiality. So all of us know who are attorneys that confidentiality is incredibly important, as our duties as an attorney to our clients. But the concept of privacy I think is a bigger, broader piece, right? And so I oftentimes find myself talking to clients about what they share and what they don't share, what they share and what they don't share. So, and as an attorney, I mean, I could be out and I could be celebrating, oh my gosh, I just finalized this amazing adoption today, and there was this really great experience that happened in the courtroom, and I share about it. I don't share any of the names. I don't share any of the identifying information. However, I'm at a restaurant, someone's next to me, and they overhear me and they hear me tell the story, and they heard from somebody else that their adoption finalized today, and they can put the two things together. So, you know, my encouragement is to guard it. Unless your client is really telling you to be as open as you want, you need to guard the information and guard what you're sharing out in public. I remember when I did a private placement once upon a time, and I was in the middle of placing the child for adoption with an adoptive family. And another a set of adoptive families came in later on, and they said to me, oh, we had friends who adopted a crack baby and blah, blah, blah. Well, I did the placement. I knew the child did not have any exposure to crack cocaine, but their experience was that. And so you have to think about it like the telephone game, right? So what you share can get twisted, and some people take it and run with it. And you want to make sure that you are guarding the confidentiality, not just from a minimal perspective of non-identifying information, but really just monitoring the privacy and talking that over with your clients and helping them understand those things too. One of the experiences that adoptive families go through in this process, like when I finalized my oldest son's adoption, I remember crying tears of joy and also tears of gratitude for it being over. Get this out of my life. Not because I didn't love everybody who was involved, but because you want it over. You're done with it and you're tired with it. Well, a lot of our families who were former foster families for the child may have been dealing with the system for years and are really tired of it and exhausted. So sometimes it's really easy to let go of that concept of privacy, because you go into a courtroom in dependency world, it's the Wild West in many ways. Information is shared all over the place. And you want to rein that back in and help them see that again. Communication with clients. Again, part of referring people is that you will, getting referrals from agencies and stuff like that, you will be connected. You may have friends who are social workers who are referring to you. I certainly did when I did a lot more of this work. You also have to guard that information and remember that you only can communicate what you're allowed to communicate. Are your clients and or the children ready to finalize, or are you rushing to meet someone else's goals or time frame? So when we look back at the former slide, we could see that there was this getting to adoption, then there was the adoption process, and then we're doing post-adoption. The getting to adoption is a really big thing, right? For most of the experiences, we're talking a year to 2 years. Once everything gets queued up and we're ready to do the adoption finalization, it's like we want everything to move fast and furiously. We want it to go quick, 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 quick. And sometimes in some courtrooms, the judges actually schedule the final adoption hearing, and everybody's got to get on board. So that's wonderful in the sense of, great, we're moving it forward. We want to get permanency as soon as possible, but you also have to remember to ask your clients if they're really ready and if their child is ready. Obviously, that fits a lot more with older kids who are experiencing lots of feelings about the adoption process. And I have my experience in sibling groups, and we have older siblings and younger siblings. The kids have different feelings about what that finalization is going to look like and when they want it to happen, when they don't want it to happen. So again, you want to have big conversations about making sure that you're meeting your client's needs and not the needs of the system. So if you need to take more time, if your client has more questions about disclosure or subsidy, take the time. The next question should say, should you also be an expert on the social work side of things? So as I mentioned, I came through working in this field because I was a social worker first. And as an adoptive parent too, I have all of these varied experiences. I use it in everything that I do. I have done the trauma-informed care trainings. I've done adoption competency trainings and things like that. It's still never enough to help all of my clients. And I find myself educating and counseling more than I end up focusing on the petition and the lawyering. I spend more time with my client in that regard. My encouragement for you is that you should be attending these events. You should be participating and learning more about the adoption side of things, the social work side of things, because you will be a better attorney in helping your clients with the long haul of adoption, right? Which is forever families, children being whole. And obviously your biggest duty and obligation is to know the law. So those are 4 links right there. Chapter 63 is the Florida Adoption Statute. Chapter 39 is our dependency statute, but chapter 39 will refer on to 63 to finalize adoptions. You also have Florida Administrative Code 65C-16, which talks all about adoptions and DCF's rules and regulations. There's a link there for DCF form searches. Some of the forms we'll show you today also include that. And the last one is the DCF policies and procedures. So I think we're going to take a pause right there and see if there are any questions.
Any questions coming in? Just a suggestion for those of us who do not have a legal background, you can also employ social workers.
Is that Madonna Finney? Yes. So Madonna is an excellent point. If you don't have a background in that, hire somebody who does, even if they're just helping train you to be a better lawyer. And definitely at minimum, if you have a need for it in your office and you can do that, hire them to work with your clients. I think those of us who do adoptions as a profession oftentimes are, whether it's your staff, they have some experience in social work. Were there any other questions?
Yep, that's it for now.
Okay, all right, moving right along. The next one is the adoption finalization checklist, and Christy is going to, I think, toggle this to my Word document, which I use as a checklist. So it'll take just a second to move over there.
There's a lot of documents. I'm not sure I can find it fast enough, but let me give it a try. Technology sometimes.
So the bottom line with checklists, which I really, really love, is that they help guide you in ensuring that you are crossing all your T's, dotting all your I's, and you are getting everything done that you need to get done. And there it is.
Is it up? Yay. Now, if I can get back to the PowerPoint, we'll be doing really well.
So what I did was put together this checklist from engagement to the consent packet, to the pleadings, to the attachments, motions and orders, and final steps for you to use as a guideline. Take it, it's a Word document, make it your own, add to it, take from it. I did put a lot of the, oh, someone says I do not see the checklist. I don't actually, I think I still just see your.
Screen. It's hard to tell what's showing on other people's screen. Let's see, it's in protected view. So let me see if I can fix that.
Okay, while she's doing that, I see a couple other in the Q&A. So someone asked about when's the right time to tell their kids that strangers visiting with you will adopt you. That's a great question. And there is no exact time. I mean, that is a conversation that has to be had with the people who know the child. And there may be actually legal rules given your specific case about when you do that and when you don't do it. I'm certainly an advocate of treating the process as if you're having a big old family meeting, and everybody who knows the child should give some input into how they think they're going to handle it. And everybody's gonna have different opinions about it. Obviously, somebody at the end of the day needs to make the decision about when and how they tell. Therapists are always great to have that conversation too.
List now.
I still don't see it.
Oh, sorry, it's showing up on my screen, so it's hard to figure out why it doesn't show up on everyone else's. Sorry about that.
That's okay. I'm going to answer one other question. Somebody asked about why in some jurisdictions, I'm not going to name the jurisdiction, there are attorneys who are getting like 90% of the adoptions in that year. So we're going to talk a little bit about that when we talk about engaging clients and getting referrals. But ultimately, Michael Tupper says you need to share the screen again once you have the document up on your thing. But ultimately, my experience is that a lot of families don't know. They don't know. And so they're given a list of adoption attorneys, and sometimes the social workers or case managers will say, I've had a great experience with this attorney. This is one you should call. I have taken my name off many, many lists that I used to be on for that. And I do a lot of just private referral for adoption finalizations. But, sometimes, again, everybody has a different view on how referrals should occur. All adoptive families have the right to choose their own attorney, whether the attorney is on the list or not on the list. And if a client comes to me and says, my case manager told me to pick you, I go back to, you need to interview other attorneys. You need to make sure I'm the right attorney for you. And again, that's part of the concept of this is not about paper pushing. This is really about providing the full experience for your clients and making sure that their needs are protected and making sure you are protected as an attorney as well, right? I mean, if they've been told you're the only one and they have to go to you, does that, does that really protect you as an attorney? I'm constantly telling people to go interview others. And then if I'm the right attorney for you, wonderful. Okay. Okay, can you see it? So it has all of these steps to it, and we're going to go through them a little bit more detail. But Christy, if you can scroll down that so you can see. So when we get to pleadings, what I try to do for you is to put in there the statutes and the specific statute and what it tells you needs to be in the petition, for example, and then the extras. So sometimes the statute doesn't say put all of these things in, but we sort of do as a practice. And we do provide for you in this training copies of my sample documents, which you will go and take and perfect for your own specific jurisdiction. My home jurisdiction of Pinellas County, we have a program attorney who reviews all adoptions before we can even get the final hearing scheduled. And so that's a really great thing because we know that it's been checked off and everything's ready to go before we get to the final hearing. Other jurisdictions do not have program attorneys to review this, and they have other processes. So you want to know what your local rules say, and you want to know how your local judges and systems work in this regard. But again, this is just a sample checklist for you. Take it, modify it that fits your needs, add to it. I recommend you use it. I'm always, as in the practice of law, I've also learned along the way too that I don't do things perfectly every single time. And it helps me to go back to checklists in case I miss something. Okay, we are going to move on to the next slide and talk about engaging your clients. So we just started that conversation about getting referrals. A lot of people get referrals because they are on the agency's list. And you should, if you're interested in doing that, contact your local CBC and ask if they put together lists of adoption attorneys, and can you have your name added to that list. You can also let your former clients know that you are doing this now, and they can refer people to you. You can get in Facebook groups, you can volunteer, you can start going to some trainings for foster and adoptive parent groups, you can start training on different topics. Those are all different kinds of ways to get referrals. Again, my encouragement is that if the referral is coming to you straight from somebody telling you, we were told you're the attorney to go to. Now, if that was a former client, you may feel more comfortable with that. If that's a case manager, you need to make sure that you step back and say, it's okay for you to choose. You need to ask me about my qualifications. You ask me about my experience. And that will protect you, and it protects them as well. Once you have the families reaching out to you, I always recommend you do a consultation. So again, the things you want to discuss in this consultation should be giving you a sense of what the big picture of adoption finalizations. And although there are lots of ways that adoptive families engage adoption attorneys, the typical foster care adoption finalizations should include some conversation about each of these things. So disclosure, were they given disclosure? What were they given in the disclosure? what's missing from the disclosure. Have they had a subsidy negotiation already? Are they comfortable with the subsidy negotiation? And some of these you're not going to be able to know unless you know a little bit more about their family. How much openness have they been involved in? Are they willing to do some level of open adoption, or is the court ordering that? Talk about dates of possible finalization. Talk about any other pending issues. Some families come to me or other attorneys because they have they're in the ARC process, so they're in an adoption review committee process, and they're potentially being selected with, one or other adoptive families, and they want to consult with me first, and we talk over things. You want to talk about if the children are over 12 or over, if they're giving their consent, how they feel about it. If they have their own attorney, do you want to talk to the other attorney? Have the other attorney talk to the child first? Have they talked about naming? So are they changing names? Are they changing part of the names? Have they thought that through? Again, you may find yourself educating at these different stages, but these should be all the topics you're talking about when you're beginning to engage your client. Other issues, so some older children may have access to future benefits, and there are time frames to that in terms of finalizing your adoption. Florida's Children First put together and an IL benefits, an independent living benefits chart, and they have a new one just updated. It's phenomenal, and I have to take a look at it every single time because there are some specific rules as we get to older kids about how much time they've actually been in foster care before they finalize and what gives them access to other additional benefits. I remember a case that I had where it was sibling groups. The oldest child was turning 18 within a month of the adoption finalizing, and we had to go over lots of issues in terms of, does she really want to be adopted? Is she ready to be adopted? What's the impact of her choosing to be adopted because her siblings want her to be adopted with them? What benefits might she lose? What benefits might she gain if she does this at this time or this at the other time? And having her be represented was unbelievably helpful in that regard. Advancing costs and fees. And this is a big conversation with your clients because ultimately, there are private attorneys who do adoptions and get paid, we get paid for our hourly rates for doing adoption work. And then there's a whole segment of attorneys who do finalizations, and that's about all that they do. And then there's some who split it in the middle. So I always charge lesser fees when I'm doing foster care related work. And I have always accepted the fee. So the way it works right now is that there's a $1,000 reimbursement. In essence, it goes to the attorney to pay for costs, attorney's fees and such. And the actual federal guidelines is really like up to $2,000, but Florida caps it at $1,000. And so and that's per child. So if you are doing one petition for adoption for one child and you're paying a filing fee and you have a court reporter and you have to cost, are you including that in the $1,000 reimbursement? Or are you charging them for the costs and you get the $1,000 reimbursement? Are you going to be arguing for an enhanced subsidy for them? Are you going to be assisting with any other aspect of an adoption finalization or representing the adoptive family in totality? You need to identify with them what you're charging them, if it's more than that fee, and so it's very clear up front. And you also have at the end of the day to ask yourself, do I want this client? So remember that just because you get picked doesn't mean that you have to say yes. And I've done this long enough to know that not everybody is honest, and some people don't have great intentions and some people have wonderful intentions. My experience has been that the majority of people have great intentions, and I'm happy to have them as clients. But there's those occasions now where, we want to walk away. So you do want to ask yourself that before you say yes and accept them as your client. Once you do, you need to put some of those details that we just talked about in the retainer engagement letter, and then you have to manage their expectations. I'm going to pause there for any questions.
A couple questions. Someone is asking, they have 3 kids that are at the point of doing overnight stays. I, as the guardian, want the kids to be told at this point. I'm assuming about the adoption, but the child advocate doesn't agree. How do I deal with this?
Let me see if I can read the question again. So you're the guardian and you have kids who are doing overnights with an adoptive family, and the children do not know that the adoptive family is adopting them.
That's what I read it to mean. I hope I'm right. Correct me if I'm wrong, Desiree.
Yeah, I mean, it's a little bit beyond what we're talking about today. I think you have to, anything you're concerned about, you raise it up the chain of command to the supervisors and whatnot. I know that can be difficult at times because some people, their experience is that there's, when you start screaming, yelling about you don't like this part of the process, you feel like, there's gonna be some retribution for that. So I understand that, but I do think you have to advocate for it. I am of the position, my personal opinions are to be more open than less open, and to make it clear up front. The adoption literature as a whole and social work definitely tells us that children should be in the know about things instead of being hidden, because then they question down the road too, what can they believe and what can they not believe. So I think you need to drive that up the chain of command. If the adoptive family is having concerns about that, certainly the adoptive family needs to know that they can talk to an attorney in advance of doing these things. And have the attorney give their perspective. If the adoptive family's on the same page with you about why aren't they being told, then that needs to go up the chain. Next question.
The next one is about consent for children over the age of 12. What if the child does not have an attorney? How do you discuss or get the information on the child's consent, name change, concerns, etc.?
And that's a really great question, right? I mean, I'm a huge advocate of children in the system should have an attorney ad litem, and this is one of those very core reasons for that. Any consent, like when you're looking at adoption, generally any consent can only be overturned in a few narrow circumstances. You err on the side of ensuring that they understand what they're doing. I think you have to look to the therapist, the case manager, to the adoptive family. The judge, in my experience, when we have children over the age of 12, oftentimes will ask the child questions directly. I know that doesn't necessarily take care of all situations where children may be afraid to say no. So again, my advocacy would be that they should have an attorney. If they don't, what I have always done from a practice perspective is, have a conversation with the family and the child is there, or have the therapist or a case manager also talk to the child.
Next person has a question about when you mentioned meeting someone else's time frame to finalize. Have you or others experienced the CBC scheduling the final hearing, even though a petition isn't even filed before you are retained?
Oh yeah, I mean, there are jurisdictions where the judge actually schedules a final hearing. I had a family who we were requesting an enhanced subsidy, and I had a supervisor from the agency go in, and after the judge had scheduled the hearing, say in open court, well, the foster family doesn't want to finalize now because they want more money. And it was, of course, a big mess. So we had to call the CBC directors, and we had to have a big conversation about this is not something we do in open court. If you have a concern about that, that needs to be brought to everybody's attention, and there should not be retribution based upon somebody asking for a potential need for the child, like an enhanced subsidy or other social service needs and medical needs for the children before the adoption is finalized. We want to make sure that's done the right way, right? There's the benefit of it being scheduled is that it keeps people moving forward. And I have always heard many times over from foster families and some adoptive families who've been a long wait, that it just is taking forever to get there. By the time we get to finalization, they want it done. They want it over with. They want the system out of their lives. And so they're thankful that a hearing was scheduled in advance, because it actually pushes everybody to get the job done. Now, your job as the attorney for the adoptive family is to make sure that they actually are ready to finalize on that day. And if they are not, you have to stop that from occurring. You have to just say, my clients are not ready, and you request another hearing date. Because once it's final, it's final. You don't want to get to the day of and have question marks. You really don't. Next question.
So last question, what are your obligations when you are concerned that an adoptive parent has questionable intentions?
Well, it depends on who you are. So if you're an
They're coming
attorney,
from the attorney's perspective.
this is a very, very, very long question. It's an incredibly significant and important question, and you will rack yourself. You need to call ethics guidelines, the ethics hotline, and to find out what the guidelines might be there about your representation of your client. What is your ultimate duty? You can't have your client go to court and lie. You can't lie to the tribunal. So you have to figure out what is it you're concerned about. You may need to have a direct conversation with your client and then determine whether or not you can continue to represent them. So that may be something that as a practice pointer in your engagement letter, you're clear about how to withdraw and how not to withdraw. That, again, very, very complicated question. And I think you have to dig into it a little bit more. And I think you're going to have to get guidance from ethics attorneys and maybe the ethics hotline as well, to identify what the issues are. Because if you're representing the adoptive family, you represent the adoptive family. You do have You can't just allow them to go to court and lie. They are signing a petition for adoption, which is verified that everything therein is true and correct. But you have to kind of, figure out how are you identifying what their intentions are, what are the issues related to that. And it is a balancing act between your duties as an attorney for the adoptive family. If you represented the adoption entity and you were doing a placement, that's a very different kind of conversation because you have different kinds of duties that go to different people, including the child. So that's a good question to ask.
I lost track of a couple questions in the chat, so we'll see if we can get
and let me just say to that question, that's actually one of the big benefits of doing that early consultation with your clients, to feel like you are making a smart choice about whether or not you want to accept them as your client in the first place. And it's okay to say no.
So here's a question from a non-attorney. I'm in the process of adopting my foster son and have not spoken to an adoption attorney, only the adoption specialist. Should I have spoken to an attorney by now, 6 months into the process?
Well, should you is not, yes, because only protects you, right? I take calls from clients and sometimes they're not finalizing until a year from now, just to help them think through some of the things that they should be considering. So my experience is, however, that most adoptive families who are through the process get the list at the end, after they've already signed disclosure, after they've already signed a subsidy, and they're ready for the agency's ready to give a consent packet to some attorney. And it's a simple, will you take my case? Yes, excellent, boom, consent is, let me tell the social worker or my case manager, and the case manager sends a consent packet, you file the petition, and boom, we're done, right? So I think this is part of saying, asking around, what are the other foster parents in your community who represented them? Who do they feel comfortable with? There's Facebook groups that you can ask that to and get recommendations. Call them and ask them. Like, again, I have had no problem as an attorney answering questions for families in advance before we're doing the finalization. I think it protects everybody. And I think that the agencies and the CBCs would be wise to advise people sooner, because of their own liability. I mean, I told you all I'm finishing my Master of Laws in business law. You learn a lot more about liabilities, risks, and responsibilities of agencies and businesses. And I think it would serve them well to tell people earlier on in the process that you have the right to an attorney and go over these things. The adoption assistance agreement's a contract that you're signing. So I recommend people do it as soon as they have any questions, or even just in general to say, I'm starting adoption process. Even if you're paying for a consultation, I used to do consultations for like $350. I'd spend 2 hours, sometimes more, with the client, just talking about adoption, talking about things you should be thinking about, things that you should be preparing yourself for. And I can tell you, almost every single one of them comes back to me and says, thank you for talking to me about those issues and questions. Okay.
So pretty much if you have questions, yes, hire an attorney, whether it's about stipends or other things, just everything you want to think about.
Yeah, and I
Get it all
think the
squared
thing is,
away.
yeah, the thing is that people are sometimes like, you know, because you get a free attorney, they call it a free attorney at the end of the day for the reimbursement amount for to do the finalization, you know, and people, I mean, a lot of families are just not rich. There's not the extra money. And if you have the extra money, you want to spend it on your child, but this is money well served for you. You know, it's adoption is a lifelong, generations long experience for your children, for your family, for your kids, siblings, for everybody involved. So, you know, you pay money to your car insurance every month, right? And sometimes you just don't use it. To me, I think that this is a great way for you to spend money. Even though at some point your attorney may get reimbursed for doing the finalization, why not pay for a consultation earlier up front to get some of these questions answered, to feel confident about the process, to have a better experience. Time-wise, we need to move
Absolutely.
on.
Yep, we will move along. If we didn't get to your question, we'll try again at the next time.
Yes. We're moving on to drafting. So if you want to advance the slide, there we go. Okay, so the consent packet is a whole set of documents that you get from the case manager, basically. And so there's a letter and there's a checklist and there's all of the documents that they need to give you, including the consent by the agency for the adoption to finalize. They're giving their consent as the legal custodian of the child to the specific adoptive family adopting the child. You will review the consent packet. You want to make sure everything's complete. Consents themselves, so governed by Chapter 63 of Florida statutes, specify they must be done with 2 witnesses and a notary. The notary is separate and apart from the witnesses. And I've had consent sent to me on occasion that didn't have both witnesses listed. I've had documents that were unsigned. They will send you almost always the UCCJEA, which is the Uniform Child Custody Jurisdiction and Enforcement Act affidavit. I've also had one as recently as this last year, and instead of it being the UCCJEA, it was a UCCJA. Old documents, I've had birth certificate forms that were old documents, so I review them all. Don't take them at, you know, that they're all done and complete. Make sure that the names are correct. And then you draft your pleadings, right? So the petition. So in most of my home jurisdictions, I do 1 petition and I have all the children in the same petition for the adoption. I pay 1 filing fee and I'm done. There are other jurisdictions that require a petition per child. I have known other attorneys who do 1 petition for all children, but then separate out and do a final judgment per child. So these are just different practices that you can do, and you also have to know your local jurisdiction. You're going to do obviously notice of related cases. The Uniform Child Custody Jurisdiction Enforcement Act affidavit must be done with basically all child proceedings. In your checklist, you'll have the statute, so you can go to it and take a look at it. And I've also given you a copy, both of the Florida Supreme Court form and then the one that I use. And you're basically telling everything, your family is signing it, and they're basically stating what they've known about where the child has been within the last 5 years. And they may not know it all, but you know, it also can trigger a conversation about maybe you should know more details about where your child's been the last 5 years. Do your consents for children over the age of 12 if they are 12 or older. And it should say 12 or over. I've put together in the packet also open adoption motions. Some people do post-adoption contact agreements, which are separate, but because in our statutes, we actually allow under a Chapter 39 termination of parental rights for there to be an order of contact. For that, I drafted in here. You may have telephonic or video hearings. You have to do a motion and order separate for that. Obviously with COVID, that has shifted because everybody's doing Zoom. And so we'll see what happens after this. But before, the standard was we always did a motion for telephonic or a video hearing. Your notice of hearing, your final judgment, again, it could be per child or joint with siblings. And then some jurisdiction require you to do, as the attorney, an order terminating jurisdiction. Hillsborough County does that. I've never had to do it in any other county. Your final disposition form for the clerk, and then your birth certificate forms. So again, you can either trust the agency's documents, or you can do your own, or you can present it to your clients and show them that and have them confirm that all the DSLs are correct. I almost always just do the new form as a rule to make sure it's done the right way. So Krista, you want to pull up the documents now so just everybody can take a kind of look at them?
We'll give it a try. You want to grab some questions while I navigate over there?
So yeah, so Heather Madigan is also saying, who's also in Pinellas, that we are going to go back to motions for telephone or video in Pinellas. In person starts August 2nd. Madonna also commented that some of the consents were notarized but not signed. Also good feedback. Let's see. Someone asked the question, are increased stipends possible for children with autism who do not have other medical conditions? And we're going to get to subsidies, so we'll talk about that in a minute. Let's see. I think I've answered all of those questions.
There's a couple of questions for you in the Q&A.
Okay. Do you have any suggestions for when a case goes to the ARC committee to assist your client's position as a prospective adoptive parent? So I've had clients hire me to do the ARC process with them. I've had clients hire me to sit behind the scenes and help them understand and navigate the process. If you as an attorney are going to represent a client in an ARC process, you need to let the system know that you are going to be participating, because they won't, their attorney will need to be there, the other attorneys or the guardian program may need to be there. You need, the best advice I can about the ARC is that go to that initial, that page earlier, I gave you the link to the Florida Administrative Code, and go to the regulations and look at what it says about the process of the adoption review committees and prepare for that. There's another link on there for DCF forms. And so you can also jump in there. Some things are out now, some things may be coming in the future. You can always look at that, but they have checklists. They have operating, DCF has operating procedures, and you should go read those and review those, because those can help you prepare your clients for what's about to come. So it's not hide the ball from your clients, although that is certainly my experience, is that a lot of families are not being told exactly what they are expected of them when they show up. And they also, you know, need to know, can they contest it, and what they're going to do about it, and how to advocate for themselves. So again, I've been in the position to help people prepare for it, think through the concerns and issues, and to not be so anxious about it. I think that's, you know, it is certainly a life experience that conversations that are difficult create anxiety. And when we have that anxiety, when we walk into the room, we sometimes miss being able to be clear about why you feel that you're the best adoptive family for this child. And so being prepared in advance would be helpful. I know there are other private social workers who help people think through these things as well, and have conversations in advance of going to ARC to help them understand the process, to help them advocate for themselves in the process. Yeah. So I would encourage them to reach out to somebody who has experience with ARC to get them prepared before they go.
Are you able to see the petition?
Do you have experience with appealing a denial of an enhanced subsidy? Yes. If denied, how likely is a family able to get an enhanced subsidy post-adoption? I don't know the statistic. I don't know if there's a percentage or things like that. I don't do them often. I mean, there are a few attorneys across the state who do these sort of regularly. And then they charge for it. I mean, I've had them denied, and ultimately the family decide not to move forward on, you know, challenging it. And then I've had families who challenged it, and it took a long time, but we finally get there. And my experience is they often get there once they've hired an attorney also, instead of just doing the arguing on their own. We'll talk a little bit more about subsidy. And again, I think subsidy is a massive conversation that could be another training for us. Okay, so if you see up, can you guys see there's a petition for adoption? So again, this is my petition for adoption. You can move some things around. Here's some things that I suggest. If you can see number 9, the minor child was permanently committed, you can see that there is the TPR that happened, but there's in parentheses, if there was an appeal, the language you would use. You also can see that I include in my petition for adoption the adoption assistance agreement and identification that the child has been determined to meet the standards of 409166, which is basically this special needs, quote unquote, special needs. And that tracks, my final judgment tracks that. I know that other attorneys do it as a separate motion and order. You can talk to your clients about that and what they want to do. I think it's very helpful for when they're going for the adoption tax credit, you have it in a final judgment as any consideration. Some people want less language and more language in there because they don't want their child seeing that. To me, again, I believe that children should know, that they should be open about it, and they should be asking the questions, what does that determination make, right? I mean, if you actually look at the special needs statute, it talks about race. And, in my experience and the research I've done on child welfare, it is, this systemic racism has existed and was created off of that. And, those are conversations you can have with your kids, especially if you have a transracial adoption. So again, all of those conversations should be with your client too. How do you feel about this being in here? Do you want it in a separate motion and order? Do you want to do that? And then that opens the conversation up, that your clients may sometimes ask you, what do you think about telling your child? And you may not have the answers to that, but you may be able to say, listen, here's a great resource. The North American Council on Adoptable Children has a great resource. Florida offers trainings for adoption competency training that you can sign up for. All of these things to help them get more knowledge about, talking to their children about adoption or talking to them about specific experiences. I know my oldest son has been asked lots and lots of things. Did you know your mom gets money to keep you? Like, kids say those things. So I don't think you can hide it from kids, right? So I've never had an issue. I've never had an issue talking through those things with my clients, and I think I would encourage you to do the same thing. The next thing we have is the UCCJEA. I'm going to skip over that, letting you all look at it on your own, just for time perspective. You have both, like I said, my document, and you're going to have the Florida Supreme Court one. You can use whichever one you want. You have a consent for the older child in there. Let's see. And I want to talk just a second about the consent for the older child, because in the petition itself, you are not supposed to you're not supposed to use the child's biological name, their earlier name, be it biological or initial legal name. You're only supposed to keep the child in the adoptive name. And so when you're doing a consent and they're having to sign it in front of a notary, then they're signing there with their biological name, because the notary can only check that ID. If the child does not have an ID, you can use credible witness affidavit. So you just have to go to the notary statutes to identify that. But, when you're dealing with a child who's 12 or older, they know their name, they know their biological name. And so I don't feel like it's an uncomfortable thing. The point, is that not everybody shares the child's biological name. Adoptive families don't always share it. And that's part of confidentiality and privacy. And so you want to talk that about. When you have a child that's 12 and older, I don't have an issue with doing consent in their name because they already know. Okay, disclosure. Disclosure to me is the beginning of the conversation around subsidy and openness as well. So my experience is there's a couple times that disclosure happens. So disclosure happens sometimes in early meetings. So when basically you're telling the prospective adoptive family about the child, right? If it's a foster family adopting, they've had the child, so they know a lot of these things. But when you have a stranger adoptive family coming in who didn't previously know the child, then part of the matching process is having disclosure meetings. And so sometimes they share documents and sometimes they don't share documents. Sometimes they just share a child study or CBHA. And sometimes they're just telling the family about the child. And then the second part of the disclosure is really the formal part of the disclosure, which is in the adoption finalization process, which is a checklist of were you told this information and did you get these documents, right? So if, Christy, if you go to the next slide real quick. This is the statute that governs the disclosure to the adoptive families from the entity on what should be disclosed, right? And I have had lots of families who didn't get documents or didn't get complete documents. I've had lots of families who, were told one thing and found when they read a document later, they realized they weren't told everything, right? So they may have had an initial disclosure meeting and they were told certain things about the child, but when they actually got the child study or they actually got medical records and documentation, they were pointing it out, right? When I ran my agency years and years ago, and we had a contract to do child studies, I mean, I can tell you that we made probably $1 on an hour for doing a child study, because the longer the child was in care, or the more complex their needs were, or their experiences with the system, the more files they had, the more documents they had, the more specialists they had, and the more you add on, the likelier there is that there'll be mistakes. Disclosure is from which much litigation can occur, right? You've matched a child, you've finalized an adoption, you forgot, oh, by the way, to tell the child that the child had a sexual abuse history. Now we have some other situations that are occurring in the house, and civil litigation ensues, and DCF is being sued, or the CBC is being sued, or all of them are being sued because, in fact, the agency knew it and did not share with the adoptive family. The DCF has a disclosure checklist. You will get that in your consent packet. And Christy, I don't know if you want to pull it up while I'm talking. It is.
I'm gonna do that. I'm also going to give everyone the link to all the materials if I
Okay.
can click over there without deleting something.
Yeah, so at the bottom, that's the link to the actual form that you're going to see. You know, to me, the real goal of disclosure is to help the family be prepared to parent a child, right? And to be able to adequately, and not just adequately, but be successful in parenting a child, you need to know as much as you can know. You know, I have, you know, different kinds of adoptions. One of my children has heart disease, and we have an open adoption. And I'm very thankful for that, because I was able to call her birth mom and say, can you please identify if anybody in your family has these traits? Did anybody have any responses to anesthesia? She was young when we had to have surgery. You know, there's benefits to that. And it may have been something that was missed in the records that was never disclosed. The other thing is, you know, I've worked privately and in the foster care system. In the private world, biological parents tend to have a better relationship with private agencies because they're making a choice about it, as opposed to if somebody has taken their children from them. And so their willingness and openness to share more information, more historical information, not just, you know, yes, I was a child of abuse, and you have this long history of the generations of, you know, kids coming in the system, but like, you know, sharing, you know, these are the things that, you know, that I've experienced. And my grandparent, you know, my grandmother died of such and such, or I have a younger brother who has, you know, ADHD, or any of those kinds of things. I mean, all of those things are helpful. When you're an adoptive parent and you're going into the doctor's office and you have very, very little information, it's difficult sometimes, right? Because if something comes up, it's harder to know. So, and you know, going to a specialist about this, again, there's actually doctors out there who review records to identify developmental pediatricians, developmental psychologists, to put together records and meet your children to identify, hey, maybe we've missed something here. Maybe there is fetal alcohol spectrum, right? Which is often, you know, misdiagnosed or undiagnosed. So the disclosure should be about giving as much information as possible to the adoptive family to help prepare them for parenting. One, to be able to say, yes, I am capable of parenting this child. And two, them being prepared to just be a parent and get them their needed services and supports. From the agency perspective, it is also about, of course, making sure that there's, you know, we're lessening liability. So as long as they've disclosed those things in advance, when the adoption's finalized, it's final.
I'm not sure if I got the right form pulled up, but
yeah, that's the consent. Can you, I think it's called, I
see it now.
Disclosure form.
I see it in the shared drive, but not on my desktop. So I apologize for that. I just did put the link to all the materials, and I will try to see if
that's
it's on
okay.
my desktop.
I gave Christy a lot, and I appreciate you managing it, Christy.
Sorry.
No, it's good. So, you know, I like the disclosure checklist, and I think you should read it and review it, because the first page is like, did you get this information? I mean, think about the things that you might want to know, and have your clients ask those questions while they're in the midst of the process. So there's the DCF disclosure form. It's in the DCF forms website. You can find it there, but this is the current one. I just pulled it. So were you informed of these? Madonna Finney gave another recommendation, which is great. The Adoption Medicine Clinic has at the University of Minnesota. There's lots of people out there. I mean, there are specialists in this area. Again, money worth spending as soon as possible. I remember when one of my kids, they who has Medicaid, and they said, oh, I called developmental pediatrician office, and they said, well, we can't get you into an appointment for 6 months. I'm like, 6 months? That's a really, really long time. Like, we need to do this now. And then I said, well, can I private pay? And she said, well, you have Medicaid, you can't private pay. And I said, well, if I were private pay, what would I get the appointment? She said, the next appointment available is 2 weeks from now. And I, of course, lit into them and said, well, then my child's going to have the appointment in 2 weeks. But this is the part where sometimes when you're the foster family, you miss some of these things because you're too busy parenting and you're too busy trying to protect your child and get your child through the system, and you're tired. But you got to come back to this too and make sure before you finalize that you get these questions answered. And even more than these questions, any questions that you have, talk to your case manager about it. Find out if there are people who are involved in the process that may know answers to certain questions that aren't in the documents. That would just be helpful for you to know. Even if somebody knew your child's birth parent's favorite color, like, those things matter to your children. They really, really matter. As much information as possible is my view on it. I'm moving on from the disclosure, and I'm going to talk about the subsidy stuff, what we call special needs, and the differences. Again, we're going to gloss over subsidy because there's just so much to it. And I've been practicing for nearly 13 years, and I go back every single time and reread it because it's unbelievably complicated. There's the statute, some of the administrative code regarding the subsidies. What I think most important for you to know is there is a difference between 4E funds and non-4E funds. And when we generally say special needs, or we say it's a subsidy, there's a monthly, basically a monthly stipend. There's also Medicaid. And then there's the non-recurring expenses, which is how the attorneys get paid. And then there's, the other piece of it is if you drop through the state, you get a tuition exemption, which we'll talk a little later. But the subsidy piece is the biggest piece, and it's where there's a lot of advocacy needed, a lot of advocacy. So there's, you can look on the forms, you can see the adoption assistance agreement, so you can see what's included in that. You can go to those two links when the Center for Child Welfare is the operating procedures, DCF operating procedures around that. Go to the regulations and go to NACAC. They have unbelievable information available to you on this. As an attorney, Seth Grobe, who's out in Colorado, is sort of preeminent attorney in this area of special needs. I have called his office several times over when I've had those situations. He has, I guess 2003, I'm not sure if he has a more recent one, article on adoption subsidies and breaking them down. If you have a 4E federal subsidy, then you can have, your family can move across state lines, and Medicaid is going to follow pretty easily. If you have a non-4E, it's coming through state funds. And again, these are generalizations, and you would need to dig into this deeper. But if they're non-4E, it's not as simple to go across state lines and move and get it guaranteed. There are reciprocal agreements between different states. And so a lot of times it is covered, but it's not always covered. So you want to check on that. I've represented adoptive families who have unbelievably complex kids with medical and therapeutic. And my experience is that most families want the finalization to occur, and then we deal with an enhanced subsidy after the fact. So there are nuances to that. And I think that's sometimes you may not even know what you need until after the fact. So what you, I think, need to know for the finalization is that their sort of basic subsidy, which is generally $417 a month. And is my understanding, unless somebody else is going to chime in here, that's pretty much now given across the state. It used to be more of a negotiated rate, and you might get 50, or you might get 150, you might get 300 or whatever. But anytime you're going over that, you're going to be, in essence, asking for an enhanced subsidy. If the child was already in a placement that had additional funds beyond that, then you generally start at like 80%, but you're going to get some part of that. You have to advocate for more than that. I had a client who was denied on a very medically complex case, and we ended up going to the media about it, and the community just supported her because the state wasn't doing the work and she wanted to finalize. You have to have the subsidy end by the finalization if you are to request an enhanced subsidy later. There are a few rare exceptions to that. You don't want to be in those categories. So what you really want to make sure that you do is make sure the finalization, the subsidy is included in the finalization before so. Okay, I think I'm going to move right on to slide 16, which is about open adoption. And again, I think a lot of people will probably have some more questions about subsidies. I think that's going to be a topic that we will, dive into in the fall, so we can get just in depth about subsidies alone.
And Maria, I just want to chime in. We've got 20 minutes left. So if you're willing to stay later for questions and
Sure.
attendees want to stay later, we can do that.
Sure. Okay. Open adoption motion order. I want all of you to pay attention to this. This is only, I think the teeth in open adoption is only going to get deeper. There's the Florida statute, and then there's the DCF regulations regarding the openness. The focus and the social work literature on sibling connections, particularly, and in general, children knowing their history is just growing. And we have a statute that allows us to put into the final judgment an actual order of continued contact. I gave you a sample of that. You need to have it. I recommend that you use it, that you know this. I think it's going to come up more and more and more. And I suggest that you talk to your clients about this. This should be one of the early engagement things that you do, because there is really no such thing as a closed adoption anymore. It doesn't exist. With facial recognition software, with social media, with ancestry, with DNA, all of those things, it doesn't exist. And people find each other. When people think they don't, they find each other. And so talking to your clients about that in the beginning is really, really helpful. Sometimes it's even just, it's helpful to know from a child's perspective that an adoptive family is being willing to be open. It may not always work, but I've navigated situations where there's been contested adoptions, and we still can create successful open adoptions afterwards, right? Just because somebody loses the case does not mean that we should throw the baby out with the bathwater, right? We should still look at, when we're trying to keep a child whole, how can we do that? And I understand that there are circumstances where there's real safety issues, but can you identify ways to help your client fine-tune some level of openness, even semi-open in the private world? We do semi-open adoptions all the time, sort of as the norm. So are there ways to do that? And I suggest you talk to your clients about that early on. Is this something that they want to do? Moving on, you have the motion in order for telephonic or video hearing. So I said, I think somebody commented, at least in Pinellas County, we are definitely going back to that. There's our samples for you. Remember that if you're ending up doing that and your client is somewhere else, that they often have to have a notary present with them. Some courts have, by video, they've said not necessary because the judge can see the ID in advance and such. Final judgment. Again, in my final judgment, I gave you a sample of mine. In my final judgment, I put the subsidy language in there. It's up to you whether you want to do that separate and apart. And I also gave you a sample of the order terminating jurisdiction. It's pretty simple. Again, some counties, the caseworkers do it, or the attorney for the CBC does it. The next slide I want to get to is slide 21, which is finalization and beyond. So again, in this whole concept that we have here of really going overboard to make sure your clients know what's going on, that you're not just pushing paperwork through. You want to prep your client, you want to make it memorable. Tell them in advance that there's videos and photos. I sometimes have brought gifts for my clients depending upon the circumstances. It might be a pen, it might be a book, it might be a card, it might be something else. Or, you're there, my assistant may have been there to take videos or photos. And you want to prep your client for the testimony they're about to give and what the experience is going to be for them, because it's a really big deal. I mean, it happens, the finalization can be a 5-minute experience, it can be a 20-minute experience, but imagine 3 years, that you had somebody in the system or an adoptive family who wasn't with that child for 3 years, but came in at the end of it, but has been a waiting family for 3 years, right? This is a big deal, a big day. You will also get my finalization script. There's another one in the dependency law website that FCF does, that Florida Children First does, and it has some other different kinds of questions. And basically, when you do the finalization at the day, you're doing an opening, you're getting the client sworn in, you're getting your testimony by the clients, you're ensuring the consents are given. So if it's an older child, or if it's the agency confirming their consent, and you're closing it and you're presenting the final judgment to the court. So you can look at my final judgment. I could say it quickly in 5 minutes, but I think you guys can read it and see the questions. You'll want to perfect that for yourself, and you really want to make sure that you are making it memorable for your client. Christy, if you'll go back to that finalization and beyond slide. A warning in advance. Kids get anxious when they're at the courthouse, right? It's not always a fun place to be. They may have bad memories of being there. If it's older kids, even if it's younger kids, you know, they may have some memory that you're not aware of, and they have a breakdown, or they're exhausted. Sometimes they dress up. I mean, I've seen a family do a whole Superman thing, and everybody got dressed up. I've had other families who brought everybody who attended a flower. You want to make sure, because it's a closed hearing, that everybody's in the courtroom when you start to have the hearing, because the doors are going to be locked. I try to sneak in the question about, why it is that you want to adopt your child. And it's usually when the tears come. You want to leave space for the judge to ask questions directly. And I try to have a conversation with the kids in advance, so I get to know them a little bit better, so you have something to kind of bring it out for them. So again, it's not a blur, right? It's going to be a blur in some regard, but if you can make it more memorable by making the experience of the finalization, by helping them be present to the experience in the courtroom, rather than just being thankful it's over and done, it will serve them well down the road. Some people use the language gotcha days. I'm not a fan of gotcha days, but it works for some people. And so you should talk to your clients about that, and talk to them about adoption positive language and what that means, how it feels. Some people celebrate adoption days different from birthdays, and they make it another big thing too. You are going to get certified copies for you, your client, and the agency. The case is going to be sealed not long after we finalize that hearing. So tell your clients, keep it in a fireproof box. I get a few more. I don't just get one copy for them. I get several copies. You can ask them in advance. You're also going to give the birth certificate form, which on a later slide, I give you the links to vital statistics, so you can see the birth certificate forms and your application. I send mine to Vital Statistics directly. I provide the one to the clerk, and then I send it directly. Some people, the clerk's office does it for them. If you have an out-of-state birth certificate, I've had some states that are really, really easy, and some states that are more challenging. Sometimes my clients themselves have just followed up with the state because they answer their questions faster. Florida Children First has a great research on tuition exemption. At the end of the hearing, my experience is that the case manager who's on top of it has an updated subsidy agreement with the adoptive name on it, and they also have your tuition exemption paperwork. Once I get the birth certificate back, after Vital Statistics amends the original birth certificate, it seals the original birth certificate. I get the new birth certificate. I send that with a closeout letter to my client and giving them the Social Security application. They can ask for a new Social Security number to be assigned for their child. I highly recommend it every single time. I've had lots of families call me from Social Security office saying they're not going to do it. Sometimes I just say to them, well, you can either sit there and fight it and talk up the line of chain of command to the supervisors, or you can go another day and get another person, or you can go to another office. But it's been a while. It's been a few years since I've had any problem with it, but they can change it. It is your right. I suggest doing it. Send the invoice to the agency. Sometimes they pay the client directly and then they reimburse you, or sometimes they reimburse me directly. I also suggest you read about the adoption tax credit. And the IRS has a great information about it. And if it's a special needs adoption, which is classified as special needs adoption, then they're going to get that off, the tax credit automatically, which I think in 2020 was like $14,300 or something. Okay, we're gonna pass through here to, we talked about the finalization. The next slide is about birth certificate. There's the forms for you. And then the next slide is special issues and resources. So I'm just going to talk about a couple of these things because I want to get to questions and answers. One, when you're working with LGBT families. So when I had if you look at the birth certificate form, it'll say parent/father and father/parent and mother/parent. So in same-sex families, somebody has to choose to be listed as mother/parent, somebody has to choose listed as father/parent. I hate it. I like the old way when we had parent 1, parent 2, but that is what it is right now. And so I suggest you having that conversation earlier on with your clients so they can process that and experience that. You also want to learn the right the right terminology as you're going to court. Second parent adoption, if they're not married, is a very complicated subject. I suggest you go to an attorney who's done them in the past and can talk about, is it being done now? Is it not being done now? How is it being done? And what's allowed. You can have someone who's married but single adopting. I gave you the statutory reference in there. Florida Children First has a great option, great resource on adult adoptions as well. Just because a child is 18 plus does not mean that they cannot also be adopted. I've done them. I've had the system repay me for the filing fees and such for the family. Birth parent readoption is another call on the topic. We don't have time for that today. Also, when DCF doesn't consent, there's some cases out there. One of the things you need to think about too is what happens if adoption breaks down when you filed the petition. So again, making clear in the beginning about when you're choosing, working with your client, what happens if you paid the filing fees and now it doesn't move forward? Are you going to get reimbursed for it? Probably not. Is your client going to reimburse you? I've never had that happen, but it's a possibility. Again, the independent living benefits chart, and I think that is the wrong link. There's a new updated link that's just because it was literally just updated. They also is a great access, information on access to records and guidelines for the release of children records, which I recommend that you look at. Now, that gives us like 7 minutes, I think, for questions and answers. And there's some links for some great places, and I suggest very highly that you get engaged and participate in more trainings.
For all that great information. And if you haven't had a chance to look at the shared materials, there's a ton in there. So I apologize for not being able to toggle back and forth quickly enough. I am not a tech wizard, but we made it this far. So we've got compliments in the chat box, lots of compliments. A suggestion: if Social Security gives your clients a hard time about getting a new Social Security number, ask them to review their own policies. I love that advice.
So Christy, let me add to that Madonna's comment. So from what I've seen, there's actually an attorney, I think in Arizona, who's gotten the documents and they put it on their website. And so you can Google it and find it. It says right on the first page when this is not for public dissemination, but they have it on their website. So
it's public now. All right, lots more compliments coming in. So one question that came in is, have you had experience with an open adoption agreement with Chapter 39 adoptions? I've never seen it. Have you seen the court order visitation with the grandparent over the adoptive parent's objection?
Not over their objection, no. I've seen it when everybody's in agreement with it. And there should be more. I mean, it's not done because people are scared of it. They're scared of it and they may be tired of it. And, if I was a foster parent for 2.5 years and there was a blown up, extended, contested case, or there was, nastiness between them at the end of the day, which happens, right? I mean, you get tired of the process. It's exhausting. You're tired of seeing your child be pulled back and forth and hurt and all this kind of stuff. It's hard to see the light at the end of the tunnel and develop a relationship with them. And I think this is where the private world, is helpful, and looking some of the literature from the private world on openness. It's available, it's possible, even if you're using a supervised visitation center, even if you're the one paying for it. Sometimes you feel like, well, I shouldn't owe it to them, but it's not, you're not doing it for the biological parent. Sometimes you're doing it for your child. And so I'm a huge advocate, even if there's been bad stuff that's occurred. Because at the end of the day, I want my child to know that I've done as much as I can do to help them be as whole as possible. And I think that that will also help generationally by breaking some of the, the continued cycle of poverty, or not poverty, but the continued child welfare cycle, right? I mean, there should be healing there done. I mean, I've seen some people get pregnant over and over again because they got their kids taken away and they still want to be a parent. If openness can help build and connect families, and that adoption doesn't have to be win-lose. In my view, that's the way that we should be heading.
Gosh, there's just a million compliments flying in, so I hope you can see all these, Maria. Fabulous presentation. Let me see if we have any more questions. Another compliment in the chat, in the Q&A box. Thank you for such a detailed and informative presentation. Someone wrote, and I don't know if this is a comment or a question, if the TPR final judgment denies continued contact and communication by biological parents. Like I said, I'm not sure if that's a comment or a question.
Well, I mean, if they say it doesn't exist, then you're not going to turn around and do an open adoption order in the final judgment because it's too quick to turn around. I am not a fan of forever and ever and ever. So I think I would argue that at the end of the day, when the adoption is finalized, the adoptive family is making that decision, and if they are willing to do a level of openness, and that there's a bridge that could be crossed there. But again, there are some horrific situations. I get that, and I think every circumstance is different, and you have to really look at each of those and get some expert guidance on it. Can't stress enough to tell your clients that if you don't have the expertise, there are people out there who do. So go to them.
Question: are there any ramifications to the adoption subsidy in situations where the court overturns a denied adoption home study?
I'm not sure. Read it again?
Are there any ramifications to the adoption subsidy in situations where the court overturns a denied adoption home study? I don't really understand the question.
Well, I think I understand the question. I'm not sure that I have the answer of that. Whoever wrote that, if you can email me, I can kind of pull it apart a little bit and to see what you're trying to ask, because ramifications is where I'm trying to think. Are you asking can they get a subsidy after the fact if the adoption goes through? I mean, I've had a contested case whereby DCF did not consent to it. We won the contested case. At the end of the day, DCF turned around and then gave its consent and we got the subsidy, but we would have been able to get it anyhow. So.
Well, other than that, it's just all compliments, all compliments. Thank you so much for a great presentation. And like I said, you all will be blown away by all the materials in the shared drive. So that will go out via Zoom tomorrow along with the recording. And I did want to announce the CLE for the attorneys on the webinar. The number is 2105071, N as in Nancy. Again, it's 2105071, N as in Nancy, and that will also go out tomorrow with the materials. Thank you so much, Maria, for all the work and time you put into this. And thank you so much to Florida's Children First for sharing this webinar with everyone. Hope you all have a great weekend.
Thank you.